Are there different charges or penalties if the accuser is underage? The answer is heck yes. Sometimes that's called statutory rape. And here in Minnesota, what you may not know is that generally speaking, the age of consent for sexual relations is 16. A lot of people think it's 18. That's not the case. There are some exceptions to that, but generally speaking, the age of consent in Minnesota is 16, not 18. In criminal sexual conduct cases in Minnesota, the law regarding the age of the accuser is somewhat convoluted, and the best thing I could do is just think of making a chart here somewhat to show you exactly what I'm talking about here for the different degrees of criminal sexual conduct and the types of trouble people can get in if there's an accusation with an underage accuser. So this is a simple chart for it. The law is a little more complex than that. I haven't gone over every part that it covers in criminal sexual conduct, but these are the broad strokes that should give you a pretty good idea. So we'll turn first to first degree criminal sexual conduct. That's the most serious form of criminal sexual conduct we have in Minnesota. And if somebody doesn't have a criminal history, meaning they've never been in trouble before, if you're found guilty of that, the guideline sentence that you're supposed to get is 144 months in prison. Generally, it can go higher than that, it can go lower than that, but just right off the gate, the judge is supposed to sentence you to 144 months in prison, which means a 12-year prison sentence. So this is serious stuff. A first-degree criminal sexual conduct involves an allegation of penetration or in this particular case, bare-to-bare genital touching. So, for example, if the accuser is under 13 years old and there's an allegation of this adult or older person having bare-to-bare genital touching with someone that's under 13 years old, that can also be a first-degree criminal sexual conduct charge. And what the law says is this: if the accuser is under 13 years old and the accused person, meaning the defendant, is more than 36 months older than that person, you've got a first degree if it's penetration or bare-to-bare genital touching. The other part is if the accuser is over 13 years old but less than 16 years old, and the accused person, meaning the defendant, is more than 48 months older and in a position of authority. So, for example, let's say the accuser is 15 years old at the time of the criminal sexual conduct alleged act, and the person that they're accusing is more than 4 years older than them, more than 48 months older, and in a position of authority. So think of coach, athlete, teacher, student, and a whole bunch of other examples there that could play in. Then you've got a first degree by virtue of the age of the accuser. Okay? Now we'll go over to second degree. A second degree, the big difference between first degree and second degree in Minnesota is first degree involves penetration. Second degree involves sexual contact, not penetration. Contact of the intimate parts, of course. So in that particular situation, the age difference again, or the age of the accuser, comes into play the same way it does in a first degree. They could be under 13 and the defendant is more than 3 years older, or the accuser can be older than 13 but less than 16, and the defendant is more than 4 years older than them and in a position of authority. So the difference is simply penetration versus sexual contact there. Down to a third degree, okay? Still a felony, still serious. Now we're talking about penetration again, just like a first degree, but things aren't quite as serious as a first degree in terms of the allegation. Here it requires that either the accuser is under age 13 at the time of the alleged sexual act, and that the accused person, the defendant, is no more than 36 months older. So they're less than 3 years older than the accused. So maybe you've got a 12-year-old and you've got a 15-year-old. Less than 3 years difference. If they're 3 years and 1 month older, this doesn't work, okay? So they literally go to the dates of birth, not just rough numbers here. Or the accuser is less than 13 or over 13 but less than 16 years old, so 14, 15-year-old, somewhere in there, and the accused person, the defendant, is more than 24 months older, so more than 2 years older than that person. Now, there is a defense that comes up here potentially especially if someone lied about their age. And that means that if the person lied about their age, that they're claiming that they were older, 16 or older, and or they didn't necessarily lie about it, but that they were holding themselves out to potentially be older than 16 or 16 or older, there is that defense. I've made a different video about that, but just know the defense is that if the defendant is no more than 10 years older than them, so let's say they're 15, we've got penetration, they're 15, they're not less than, they're 15 years old. So in that situation, for that defense to operate, okay, let's say the accuser is 15 years old, the accused person, the defendant, is no more than 10 years older than them. So it doesn't work if they're 15 and you're 29. But if they're 15 and you're 24 or something, you can raise the defense that you reasonably believe them to be age 16 or older at the time. You've still got to prove this. That's a separate video, like I said, but that defense does exist. And finally, into a fourth degree, this is again this is not a penetration situation for fourth degree. It's sexual contact. And again, the law structures it so that if the accuser is less than 13 years old, then you've got a situation where it's a crime if the defendant is no more than 3 years older. If they're older than that, then it becomes more severe, of course. But it's a fourth degree if the defendant is no more than 3 years older than them. Essentially, the defendant is also still a kid under the law to a degree, and they're not going to go as serious as someone when they're a young defendant and they're closer in age to the alleged victim than if this is an older adult that is 36 months or older. So you see how that works? And then also, in addition to that, for a fourth degree, you still got that defense where you reasonably believe them to be over age 16. And then finally, you could have a situation where on a fourth degree for sexual contact, the accuser is over 16 years old, but less than 18 years old, but the defendant is also more than 4 years older than them and is in a position of authority over them, or has a significant relationship to them. Think of family members, for example, for a significant relationship. They don't have to be blood family members. Or they're using force or coercion or some other things. So that's a lot going on here, but these statutes can get rather intricate, but you ought to know about these. Yes, the age of the accuser does matter, and the crimes get that much more serious if the age of the accuser especially is under age 16, or even greater if they're under age 13 here. If you have more questions about that, you can contact me. I've got a support page up on Facebook for those that are wrongfully accused, supporting the wrongfully accused in Minnesota. You can go there and join that. Or if you have more questions, you can call me at 612-339-5844 or shoot me an email, ryan@arrestedmn.com.